Any mention?
Lordship, item 56. Item 56. This matter is returned from the mediation, could not be settled. So let it come for final hearing after 2 weeks.
Is there for hearing today, Mr. Jindal?
Yes, I'm not ready today. I'm not ready today.
Oh, okay. When?
After 2 weeks.
No objection, I suppose.
No, I told.
Yes.
So what matter was there? Item number 61, my lord. I just need to complete the instruction, my lord. I need to discuss with the EE of the principal before I take up the hearing.
But then you've been adjourning this matter.
Yes, my lord. I could not get. My lord, next week, any date, my lord. Next week, we'll do it.
Please, your lordship. Next week, there's some personal difficulty. Not be able to be there.
After that, my lord, because I will be meeting with him today in the evening. I'll complete my instruction, my lord.
See, why I know a difficulty. But the only query from the court is,
yes, my lord.
Be does it may seniority whatever, but then where under what rules are appointed, how they promoted, what cadre they belong to.
That is what, my lord.
Well, in this case, what case I've made out is that a person who's in waterworks manager, a lady who's working in the office, she'll be transferred as waterworks manager, and then a person who's doing with the spanner and wrench, he'll be sent to the office. This municipality has to, streamline those things.
If my lord see the affidavit, not very clear about that.
Not clear.
Not very clear.
That's why we want just under what rules are appointed. Whether
my lord.
Where is
any rule or
have separate ministerial staff for your office and
I will take the instruction today itself.
There's no division, technical and ministerial staff.
I have to take the instruction, my lord. I cannot make any comment at present, my lord. I will take the instruction today positively. I will complete the instruction today.
Otherwise, person holding a wrench will make him hold a pen the next day. 2 weeks, yes.
My lord.
Yes, request of interim order of any country. Interim was there.
Your lordship is until further orders.
Okay.
Highly obliged.
Please, your lordship. Item 57, my lord. Accommodation work after 2 weeks, my lord. Positively, I'll contact hearing.
How many hearing matters is there?
Yes, my lord. 57, my lord.
Lord, I have no objections.
Highly obliged, my lord.
Please, lordship. Lordship, I beg to make a mention of item 60.
Dr. Mozika. What's the matter about?
This regarding
the time-barred arbitration prayer. Yes, you do it. What is there?
Lordship, next week, lordship.
Where's Mr. Paul?
He's online, lordship.
He's online.
Lordship, but we required some time, sir, lordship. It'll be next week.
Pendency will not improve the case, man.
Next week, my lord.
There's nothing in this case.
Lordship, we will try to.
You'll try when?
To make out our case, your lordship.
You try when?
To make out our case, your lordship.
But tell me about your case. Of course, you have to make out your case. What to do after 1 week? Yes.
Highly obliged, lordship.
Yes.
May it please your lordship, I beg to mention item number 64, lordship. This is a joint request, lordship.
What's this matter about? Where's the other side?
Defreezing of bank account, lordship.
Yes. Who's the other side?
For the private respondent, Dr. Todi is appearing, lordship.
Who's local counsel? You have no objection. You're appearing for the state.
I'm appearing for the police station, lordship.
Mr. KP Barasaji?
64.
You're appearing for whom? You're not appearing at all here.
Well, Lord, Mr. Todi had instructed me.
Okay, yes. Yes.
Highly obliged.
Wait, lordship.
Your lordship, I beg to mention item number 62. I'm appearing on behalf of Mr. P.R. Paske.
Mr.
P.R. Paske.
No objection, your lordship.
No objection?
No objection, your lordship. Your lordship, status quo may be extended, your lordship.
Yes. Paske is appearing for respondent number?
Sole respondent, your lordship.
Sole respondent. Yes, sir. On the prayer of your name?
Miss B. Thaba.
B. Thaba.
Yes, Your Honor.
Counsel for this respondent this summer for 2 weeks. This interim order, status quo order to continue. Yeah.
Much highly obliged, your lordship.
Supplementary list item number 1.
It's the contempt against your lordship's order, your lordship. This pertains to ACP upgradation. Order has not been complied.
Direction?
It'll be at page 11. Lordship. Thereafter, the respondent had preferred a review, lordship. Page 18.
6 months.
6
The
months.
review was passed when?
Review was on 9/12, lordship. 9/12/25.
But 6 months haven't passed then.
But
After
counting
review
from the
order has been
first order,
passed.
lordship.
Yeah?
The first order, lordship. Because the review is only to the extent that the date of remonstration or the initial date of entry.
Even then,
Not on the merits.
I think it's premature. It's premature as contempt, Dr. Mazika. Because initially this is with the review order.
Review orders at page 25. It's not gone to the merits of the case, only to modify the.
Yes.
I'll have instruction.
You've heard Mr. ML Nongpur, you should notice.
Vice M. Chanda, lordship. He's on legs. Lordship. Vice M. Chanda is on legs before the
Vice
division bench.
President, Thomas? Yes, sir, you should notice. You accept the notice?
Yes, ma'am. 1, 2, and 3.
On behalf of 1 to 3.
I'll file local comments.
Dr. N. Musika is present on behalf of 1, 2, and 3. Just after 3 weeks for affidavit.
Obliged.
Item number 2.
Similar orders, lordship.
Connected, madam.
3.
Chief, I pray for at the bottom of the list, Lordship.
Bottom of the?
Bottom of the boat, Lordship.
What's the matter about?
This is
Mr. Kriam said Mr. Paul's in court number 1 just now. On legs. No sound coming.
Am
I audible now, my lords?
Yes, yes. What is this?
Well, this is a matter regarding this teachers matter. What had happened is, the development is that this honorable court via the judgment, insofar as the CBI proceedings are concerned, that have been set to naught.
Yes.
So, what had happened is earlier, by virtue of certain orders passed by this honorable court, my cases were directed to be reconsidered by the state. Now, the foundation of the consideration by the state, was on the basis of the CBI report.
Okay.
Now, with the CBI report gone, we are before your lordships that this is something that the state, our prayer is the state re-examine our case in light of the fact that the CBI proceedings have been closed by this honorable court.
Where's your prayer?
I'll just take your lordships to my prayer.
Oh, it's those tainted teachers.
Yes,
Can his bench take up this matter?
I have no reservation, your lordship.
My limited prayer is only that we reconsidered, because what had happened, there are two committees. The original committee, there was a committee headed by the then secretary, chief secretary, Mr. M.S. Rao. Now, he had considered the matter in a certain perspective. The subsequent batch of writ petitions, they were considered by the second committee. Now, in that, emphasis was given to the CBI report. That is where the grievance is.
Okay. Okay, so asking for a relook or revisiting the entire.
Our limited prayer is, in view of the judgment of this honorable court, that the entire aspect can be re-examined by the state.
Yes, Mr. Shulai.
May it please your lordship. Lordship, can you have the prayer, lordship?
That's what we're looking at the prayer to.
Lordship, the prayer is for setting aside of the committee report dated 14/5/22, your lordship. Now we are in 26, your lordship.
Whatever it is, the thing is that, see, because of changed circumstances,
Lordship, kindly see, Your Lordship, whatever has been done by the state is in pursuant to the direction passed by the division bench of this court, Your Lordship. A committee has been set up, examined, and found those people had to be tainted, Your Lordship, and accordingly they were removed.
No, see, the
from
basis
service.
of the argument is that
Then,
everything said to come to zero.
Lordship, then only when the criminal proceeding had been set aside by this court, Your Lordship, where certain people they have challenged before this before the High Court, Your Lordship, against the continuing of criminal proceeding that had been set aside, Your Lordship. Only after that, Your Lordship.
What remains now?
Lordship, the fact remains, Your Lordship, prior to the set quashing of all those criminal proceedings, Your Lordship, these have been done, Your Lordship.
Whether there's any, possibility of the matter being relooked again?
Lordship, in my humble and respectful submission, it will amount to unsettling the settled position, Your Lordship. There was a direction, Your Lordship. There was a direction, Your Lordship.
By virtue of the fact the findings recorded by the
there was a direction, Your Lordship. A direction is to consider, Your Lordship, the tainted and the untainted, Your Lordship.
No, we understand, Mr. Shulay, but whether the petitioners here can still hope for some relief, that is what.
Lordship, in my humble and respectful submission, Your Lordship, my submission would be in the negative, Your Lordship.
Like there's no hope.
There's no hope, Your Lordship.
File affidavit then.
Lordship.
Yes.
Let an affidavit come from the
May I
state.
have Mr. K. Paul, National Council with whom? With Mr. Chanda.
Mr. Chanda and Mr. Sheikh Malans, both of them.
With Mr. Council with Mr. S. E. Sheikh and M.S. Chanda for the petition issue notice. Mr. N.D. Shulailer, EAG with A.R. Khan is present on behalf of the state respondents. No further notice.
All respondents.
This is a matter after 2 weeks or 3 weeks for
2 weeks.
Lordship.
2 weeks
Lordship.
for instructions affidavit. Yes.
Lordship.
Highly moved.
4? Item number 4?
Well, it's item 4 is the same.
Lordship, in my item 4, Your Lordship, is different, Your Lordship, because what happened, if Lordship kindly have if Lordship kindly have para at page 29, Your Lordship, para 18. Earlier, Your Lordship, the report of the committee.
Page 29.
Page 29, Your Lordship, para 18.
Yes.
In 2000,
come back to this honorable court.
in 2022, Your Lordship, they have
Where are you reading
challenged.
from?
Lordship, at para 18, para 18, page 29, Your Lordship.
Okay.
Lordship, can you see that some of the petitioner herein file a writ petition number so and so before this court against the 3-member committee report dated 14/5/22. The said writ petition was withdrawn by the order dated with the liberty granted to the petition to file afresh. Lordship, this is conditional, Your Lordship. If I may place, Your Lordship, the order. If Lordship kindly have paragraph 3. Accordingly, liberty is given to the petitioner to withdraw WPC number so and so with liberty to file afresh. However, it is made clear that such liberty will hold good if the petitioner had a cause of action or right to WPC number 4-75 of 22 in the first place. This liberty may not be construed as fresh liberty irrespective of whether any cause of action or right survive at the time of the institution of the present petition, Your Lordship. Kindly see, Your Lordship, in 2023, that petition has been withdrawn, Your Lordship. And only in 2026, Your Lordship, when everything had been set aside by this court, Your Lordship, in those criminal proceedings, that the petitioner have approached again.
Okay, we'll issue.
May I pray?
No, we'll issue notice. We'll have this matter. We'll post it separately. Another matter.
Then whatever objections they have, let us put it on record.
Lordship.
Heard Mr. K. Paul, Mr. Council with S. E. Sheikh and Mr. S. Chanda stop issue notice. Mr. issue notice stop. Ms. N.D. Shulai, the EAG at the outset has also who's present on behalf of the respondents.
All
N.D. Shulai,
respondents.
the AG with A.R. Khan, who's present on behalf of the respondents number. All the respondents.
Lordship, yes.
All the state respondents.
120.
Yes, submits that the writ petition is not entertainable in view of the order dated 15/6/2023 passed in Miss Case bracket WPC number 41/2023 arising out of WPC number 475/2022 as much as the liberty granted therein was conditional. Leonard Senior Counsel submits that for the writ petition to be sustained, the petitioners have to make out a good case that they have a cause of action and the right to institute the earlier writ petition that had been withdrawn, namely WC number 4725/2000. Mr. Paul, Senior Counsel, praised the matter be and praised that the matter be dismissed for admission. Accordingly, this is a matter for admission hearing. See respondents to file objections.
Lordship.
Entertainability in the middle of the
Lordship.
Yes.
Highly apply your Lordship.
This also.
Lordship. Apply your Lordship.
5.
Please, Your Lordship. This matter also relates to the standard table of rent fixed by
the order we passed.
Same. That's fixed on the 13th. May come up on the 27th itself.
That's coming on 27.
In Supreme Court.
No. The previous writ petition that I filed last week, my lords.
So what happened in the Supreme Court matter?
It's still at the same stage, my lord. No further orders. This is the previous writ petition that I filed last week.
Same respondents.
Yes, ma'am.
Supreme Court only stay with regard to the eviction, no other process. STR has never been stayed.
This matter, the instant matter, is identical to, similar identical to WC number 101 of 2026, wherein same issues have been raised for consideration before this court. So placed together with WC 101 2026 on 27/3/2026. Copies of petitions to be supplied to the.
It's already supplied, madam. It's out.
Amper 1, 2 and 3, Mr. Vantaj.
Yes, we record Mosika 1, 2 and 3, Espanta 4 and 5, and
for the state.
MSD Yangi B for 6. 6 with 6 years.
You were 4, 4 and 5.
Number 6.
Obliged, madam.
Now, what is this?
This pertains to my lord's summary dismissal from service. Now, what had happened is the petitioner has been in service since 1999. Now, his last extension, my lords, was in the month of December. And my lords, he was, my lords, I'm sorry.
Which office is this?
2019. I'm sorry, my lords.
NCC headquarters. You have to issue notice then.
My lords.
Yes, you are paying for 1, 2 and 2.
I'll pay for 1 and 2.
Because this is group commander.
Yes.
Heard Mr. K. Paul and counsel with his for the petition issue notice. Mr. Kivarachadi is GLNG accept of 1 and 2 notice to go to spot number 3 within 3 days. Just after 2 weeks, yes. For further orders. Yes, on. Right. Just on the further orders. Just after 1 week, on the further orders.
Daily list item number 1.
Please, His Lordship.
So this is that matter, review matter, Lordship, regarding the second appeal, Lordship. So you are at the stage of admission hearing, Lordship. Leonard Senior.
Yes, Mr. Paul. Yes. Can't hear you. You're muted. Now, what? Yes.
Yes, Malits, I was praying if this matter can kindly be taken up next week, Malits. This would require me to assist my lords physically, Malits. This is that review matter.
The records have been received. Yes, Mr. K. Paul prays that he.
I have filed no objection as well.
The matter be taken after 1 week physically. So, enable to be present physically. Prayers allowed, yes. Received, yes.
This already.
Item number 2.
So these are dead duck cases.
No, my lord. In fact, I have filed my rejoinder.
Whatever the case may be.
I have filed my rejoinder. Now I have been, my lord, wrongly disqualified, my lord. I have brought on record, my lord, the general financial rules of
Mr. Gautam, I
2017.
will dispose of your petition.
Just one small,
Only remedy,
just small submission, well, if I may.
is alternative remedy, my lord.
File a civil suit.
One small,
for,
one small.
It has been executed, my lord.
submission.
That is, you're Bajrang, right?
Only thing is, my lord, Lordship will see page 17, my lord. Lordship will see that of the writ petition, my lord.
Yes.
I know.
My lord, time of completion is 120 days. And my lord, supply 120 days, but thereafter, my lord, if we see
Page
clause
17.
17, page 17, my lord.
Sorry.
Time of completion of supply is 120 days. And thereafter, my lord, clause 17 on the other hand.
Page 17.
17, my lord, time of completion 120 days. But then surprisingly, my lord, when we see clause 17, which is at page 19, if I may read, my lord, if the circumstances warrant, the director of housing so-and-so, the prior approval of the government in housing department may reduce the quantity of material ordered, and no claim for compensation on this account shall be entertained by the department. Similarly, the director of housing, with the approval of the government, also reserves the right to increase the quantity of the materials ordered any time, same approved rates. So, my lord, if this goes on, my lord, I will never be allowed to participate. So there should not be any increase any further. My lord, there should be a fresh tender. Let everybody participate. That's the only case left.
Now we'll close this matter now.
That observation, my lord, that observation is okay.
Then come to rejoinder.
I filed my rejoinder, my lord. Now, my lord, in my rejoinder, I have brought on record, my lord, the general financial rules of 2017. This is the Government of India general financial rules. These general financial rules have been adopted by the Finance Department of the Government of Meghalaya as well. If your lordships kindly have page 9. I have just reproduced the extract.
Yes.
If your lordships kindly have page 10, rule 170. So, my lord, it starts with to safeguard against bidders withdrawing or altering its bid. So this is the reason why bid security is given. Now, my lord, in this very paragraph, around 10 lines from the bottom, my lord, on the right side, it reads, the bid security may be accepted. Has your lordships found that? Around 7-8 lines on the bottom.
On the right side.
The bid security may be accepted in the form of insurance, surety bonds, account payee demand drafts, fixed deposits. This was my case, my lord. These are adopted by the government, my lord.
Too late in the day now.
Yes, my lord, but as far as, my lord,
We'll have
for wrongly
yes.
being, my lord,
Yes.
disqualified, my lord, I should be compensated. That is one thing, my lord. And the other thing is, my lord, what my learned friend was just pointing out in the other matter. If your lordships kindly have my writ petition. Writ petition, my lord, page 27 is the notice inviting quotation, NIQ. Page 27, annexure 2.
Yes.
Now, your lordships kindly have the table.
Yes.
So, my lord, the second row, my lord, it reads, my lord, approximate tender value. Tender value is 69 crores 65 lakhs. This is the tender value. And time for completion is 120 days from the date of supply. So, as on today, my lord, the entire 69 crores 65 lakhs have already been, my lord, supplied.
Yes.
So 120 days has, my lord, also completed. Now, page 29, rule 17 again pointed out by my learned friend. They should not misuse this clause. This clause says that it can be reduced or increased. Reduce or increase means within the 69 crores 65 lakhs. Not that you start going beyond it and go to 200 crores. So there should not be any repeat orders, my lord. If at all, my lord, there has to be fresh tender. This clause cannot be misused.
Right. Yes, Mr. Shwai.
May it please your lordship. If a lordship kindly have page 197
of the writ petition.
Of the writ petition. That is the judgment dated 28/8/2025, Your Lordship. It starts from page 191, Your Lordship. I'm page 191, Your Lordship. That is the judgment passed by the division bench in the writ appeal.
Yes.
Then, if Lordship kindly have page 197. Lordship, second paragraph from the bottom. We think that the tender process should be thrown wide open. The eligibility of Manaksha Aluminium Company Limited and MS Miriam Commerce Limited be considered afresh by the tender committee by giving them a short hearing and by a recent order within 4 weeks from date. Then, Lordship, we file the affidavit. If Lordship kindly have our affidavit, Your Lordship.
Which one? There are two affidavits.
Minaksha. No, the first one. If Lordship kindly have para 7 at page 4, Your Lordship, yes. That is the affidavit dated 3rd February 26, Your Lordship. Page 4, Your Lordship, para 7.
Yes.
If I may read, Your Lordship, that based on the scrutiny, a notice dated so and so was issued to the
Mariam Commerce is Mr. Chariso.
Lordship, Manaksha.
No, Mr. Sen.
Oh, sorry. And Mr. Chariso was?
Meghalaya.
Not the picture anymore.
No. It's pending before the tender committee, this case. Your Lordships had remanded that matter.
Remanded by the matter?
Yes.
Lordship, yes. For the departmental tender committee to take a fresh consideration, Your Lordship.
25%.
Yes.
Lordship, yes.
Yes, sir.
As well, Lordship, as well as so and so, informing the deficiencies and directing appearance for a short hearing on so and so. The petitioner Manaksha appeared and submitted written clarification, and after evaluating the same, the departmental tender committee passed a recent rejection order dated so and so, which is however, Miriam Commerce Limited did not respond to the notice and even to the email which was sent to the firm informing them about the hearing. Considering that the firm did not communicate the willingness to attend this hearing, therefore the departmental committee resolved to consider the matter closed. Then Lordship kindly have a para 8 that the detailed examination the departmental tender committee found multiple serious non-compliance with the NIQ with regard to the petitioner. Invalid earnest money deficit. The NIQ clause B technical bit require EMD to be in the form of call deficit, bank draft, demand draft payable at the Shillong and pledge to the Director of Housing Meghalaya Shillong. However, the petitioner submit only a deficit confirmation.
What are you trying to show by this?
Lordship, they did not fulfill the yes, Your Lordship. Because Lordship,
pressing that anymore. Just a future that there should be, a level playing field. That's all.
That is Lordship. That is
that
for
should be, that also is very, because just to make a small observation is that the whole matter is very, very happy with the way
if a fresh tender is called, Your Lordship, I believe, Your Lordship, that this
now
the clause may be the same or may be different, Your Lordship.
Whatever the issues here, we're not going to rake it up again. Now the department will look at 25%, 75 is already, forget the rate.
Lordship, yes.
But in future, at least there should be a transparent, and very what do you call it, definite kind of tender requirement.
Lordship, I make that observation, Your Lordship.
Otherwise, if you play around, then it becomes difficult.
The cause of action is not reasonable.
That is
25% is not been settled till now. Now they are talking about
the future of future contracts.
It's on public interest. Yes. If we also settling this public interest because it's for below poverty line families to provide them roofing sheets. They are entitled to the amount of money that is being spent to to good durable roofing sheets at reasonable prices, which has been supplied. Maximum what do you call it, benefit for these people. We'll pass orders then.
Lordship, highly apply, Lordship. Offer.
Item number 4. 4.
Yes.
Please, Lordships. Lordships, it is listed for the cross-examination of respondent witnesses today. So 2 witnesses have been summoned, one the stamp reporter and the notary.
One is?
Notary officer.
Available today?
Stamp reporter is here, Your Lordship. So far my instructions are, but I am not sure about the notary officer, Your Lordships.
Are they ready now?
I am ready, Your Lordships, or
Then we take just after the...
or at 2 o'clock, Your Lordships, if that is convenient, or after the matters.
After the listed matters.
Please, Your Lordships.
Item number 5.
Still pending. It's still pending, no? I think the matter in Supreme Court is still pending, Your Lordship.
This is regarding boundary dispute.
No, Your Lordship, that compensation, that airport compensation, Your Lordship.
Before the Supreme Court?
Lordship. Let come after 6 weeks, Your Lordship.
Yes, it is reported that the matters is pending consideration for the now Supreme Court. This is a matter after
6 weeks, Your Lordship.
8 weeks. Yes.
8 weeks. Highly obliged, Your Lordship.
6.
My lord, we have filed an application including the respondent.
Impleading who?
Impleading the acting CM, my lord.
Your Lordship will be filing our power today, Your Lordship.
Acting CM?
Yes, Your Lordship.
You have no objection? Yes.
So let him be impleaded, my lord.
Yes. An application for this is an application. This case number 51/2026. In this case again.
Yes, my lord. This case number 213.
This is this is an application impleading the acting aim cross aimship as part of Respondent number 7 in the incident matter. The same was objected to by the counsel for the respondents. The acting aim shall be arrayed as Respondent number 7 as in the incident proceedings. Yes. This case stands allowed registry to make necessary correction in the cross title. Similar in all of them.
Yes, yes.
How many miscases are there?
43, my lord, if I'm not mistaken.
I have one order. Yes.
Common order.
Right, Your Lordship.
Just after the main case?
After 2 weeks, my lord. On the meantime, okay.
As Mr.
Emling Doyle, Your Lordship.
sent to the parents on behalf of respondent number
7.
Newly impleaded on the 7, gives the matter after 2 weeks.
Right, Your Lordship.
49.
The main case.
49.
In this case, Your Lordship, on the last date, I had made a prayer that I would be filing my affidavit in the course of the day, Your Lordship, but the officer from Garo Hills could not come, Your Lordship, so we couldn't file, although we have given advance copy to the other side, Your Lordship.
Now, why was the statement made that you already filed?
No,
Yeah,
in course of the day, Your Lordship.
No, filed. This last record is already has on behalf has been filed.
We were supposed to file it in course, waiting for the officer to come and sign, Your Lordship, but he could not come because of the law and order situation of the bench.
Here, Lordship, I am representing the managing committee, Lordship. Here, my Lord, this type of issue, Lordship, the salaries are paid from the salary of the sanctioned teacher, Lordship, because there is no extra aid from the government, Lordship. Now, what happened? The petitioner herein, he has filed the writ petition. It is not a case because of the filing of the case that we have stopped the salary, Lordship. Now, from the resources, whatever they have, they are trying to find out some ways and means to make some payment to the petitioner, Lordship. Because now the sanctioned teachers, they have stopped the salary. They are not giving any share to the other teachers, Lordship.
But my lord, this teacher is in the sanction post.
Internal arrangement between the
This is a
management committee
sanction
and the
post, my
sanctioned
lord.
teachers.
How can they say it is not correct?
No, my lord.
Let him give an affidavit on that point.
I'll file the.
He's not a sanctioned teacher.
No, Lordship. My
lord,
prayer
it is
is
sanction post getting salary from the government. How can he say that people are, other teachers are contributing? This is not correct, my lord.
Even my salary has been also stopped because of the managing committee.
You're a sanctioned teacher.
I'm
My lord, kindly see the prayer. Prayer is page 8, lordship.
Okay, what does the prayer say?
I'll just read, lordship.
Yes.
Would be pleased to admit this petition call for the records, and after hearing the parties pass necessary orders directing the respondent to appoint the petitioner against the sanction post. Now the senior counsel is saying that I am a sanction post.
No, but she's getting the salary from the government. Every month she's getting.
We need affidavits. Yes.
So we'll file the affidavit.
Submitted today submits that though by order dated 26/2/2026, it has been reported that the affidavit on behalf of the respondent wanted to be filed. The same is due to inadvertence could not be filed. Or the same is not correct due to inadvertence. The submission was made for this court. So she submits that the non-filing of the affidavit on that day was due to the non-availability of the officer.
Yes, from Garhils.
So could not come to learn of the situation. Stop the especially
Advance copy was given, Your Lordship.
Submissions accepted. Stop further 1 week's time is allowed for. You find today?
Not today because the officer is not yet available.
Within 2 weeks, yes.
2 weeks.
2 weeks from today. Stop. Mr. S.A. Sheikh of 104 and Mr. S.K. Hassan for 5 and 6 also have similar prayer. It's some tweaks of affidavit, yes.
Oblige, Your Lordship.
50.
Your Lordship, I'm appearing on behalf of Respondent 124. I'm seeking further time to file affidavit, Your Lordship.
What's the matter about?
The matter pertains to the appointment of the Sodar in Maupan Rao, Maulain Pulun, Your Honor.
Now it is acting Sodar, or what is the situation?
This institution has a religious duty, Your Honor.
No, I mean, what's situation now? Is somebody in place or no?
No, Your Lordship. The District Council has called for a referendum. This Honourable Court has stayed the referendum of the election.
Yes, MSPS Nambri, General Counsel 124. Praise allowed for the 2 weeks time for affidavit. None appeals 145. Just after 2 weeks, yes.
I'll oblige, Your Lordship.
51.
May it please, Your Lordship. Lordship, I'm seeking 2 days time to file the affidavit.
Yes.
Yes, Lordship. Let the file.
Yes. You are appearing for number 6. File, you already filed. Yes, Mr. Jan Janja for 1, 3, and 5. What about number 4?
Number 4 is government.
Number 4?
My Lord, I'll be representing number 4 as well.
1 to 5.
Lordship.
1 to 5 praise counsel for the 1 week's time to file affidavit. Stop Mr. Sinkrem on behalf of some 6 subjects that affidavit has already been filed. It's just after 2 weeks.
Lordship. Deeply obliged.
What's the rest, Lordship?
52.
Here we have already filed the affidavit, Your Lordship.
Yes, I have received the affidavit, and also Your Lordship, the police had informed the court, Your Lordship, that they have filed a FR report, Your Lordship, and a closure report. It's found nothing against the petitioner, Your Lordship. This
What's the matter about?
Your Lordship, here, Your Lordship, the petitioner had applied for the post of Gram Savak, Your Lordship. So he passed a written examination, and he also passed a personal interview, Your Lordship. And the District Selection Committee has
He was selected, but appointment letter was not issued, Your Lordship, because of the criminal case investigation. Now it appears that the police have given a
closure report.
Closure report regarding the investigation.
Yes. Then what to do?
Your Lordship, may kindly fix another date, short date for hearing, because I'm a little handicapped. I don't have the file with me today.
Has produced an order of this court dated 5/3/2026, passed in criminal petition number 73/2025, which reports that the cases against the petitioner has since been closed. Stop. MST Yangi So praise allowed to obtain instructions
Yes, Your Lordship.
within 1 week. Yes.
Oblige, Your Lordship.
Copy of the order dated. So Sultan's taken on record.
All right.
53.
This is for affidavit.
No, I need some time to file my affidavit, my lord.
This is a pension.
Yes.
Pension of the ex-MDCs, my lord. Lord, on the last occasion, my lord's state government made a statement that they are only a performer party. They will not require to file any affidavit. However, the first prayer is against them for release of the amounts.
Lordship, their prayer is mainly for a grant of pension, Your Lordship. Pension, if the dismissal in their wisdom had given the pension, they should generate their own fund, Your Lordship.
But the prayer is otherwise. They have to release it.
So therefore, my lord, they'll have to file.
We'll file our affidavit, my lord. Let it come after 3 weeks, my lord. This matter. We'll file it positively, my lord.
Yes, Mr. SD, on behalf of respondents 4 and 5, please further 3 weeks time to file affidavit stuff. Not excessive like that. Let's see next time. Don't file us to the detriment.
Deep.
54.
You're appearing on this? Your Lordship?
Yeah, for the
Or
assembly.
assembly?
May it please Your Lordship. Lordship, in this matter for the assembly, we need another week's time, Your Lordship, to file the affidavit.
The state
How
is
many
not
AGs
filing.
appearing here? You appear
No,
for
I'm appearing for
Lordship,
the
here
state, Your Lordship.
in the senior council, Your Lordship, for the assembly. For the assembly, respondent number 2, Your Lordship.
And I'm appearing on behalf of number 1, Your Lordship. And we are not filing an affidavit.
Number 2, you're appearing with Mr. Shulai.
Lordship, yes.
Yes, Mr. N.D. Shulai, Senate Senior Counsel, order number 2, raise funds allowed for a 2 week time for affidavit stuff. Yes, 2 weeks. Yes.
Lordship, highly obliged.
55.
55.
This is the matter, my lord, pertaining to NOC from the headman, my lord. Now it appears, my lord, the headman is in the mood of defiance, my lord. Now what they've done, they've appointed their own people, my lord.
Come here. Come here.
The headman is appointed and collecting electricity bills.
Mr. Chareso, you've done that?
We don't have that instruction, my lord. Lordship may
And, my
give us
lord,
a 10 days time.
By the first order, my lord, there was a direction for respondent number 7 to appear in person, my lord.
Yes.
That has not been complied with till now.
With the newly impleted respondent number 8, my lord, the Sunjuk. I'm entering appearance today, my lord. I've just been instructed this morning to appear. You know, kindly grant us some time. We'll file the Wakalatnama and also the counter. Because there are some issues, my lord, which have to be resolved. We have nothing against the petitioner per se, my lord. It is the government, my lord. This is a case of, my lord, privatization of the power sector, my lord. And in the Khasi Jainte districts, it is only this Mausanram subdivision, my lord. We are like a guinea pig, my lord, where this experiment is going on. So we have certain genuine grievance, my lord. We are the consumers. Around 300 villages, my lord. Auklang area, my lord.
What do you mean by guinea pig?
Well, they're experimenting this privatization in this only in this subdivision and not the entire area, my lord. So, my lord, we have some genuine grievance, my lord. We have placed it before the government. We were in dialogue with the government. Now, my lord, those issues have to be resolved, my lord. My lord, our electricity bills, my lord, as consumers have doubled and tripled, my lord. All those grievances are there with the government. We are not aggrieved by
parents. To ensure our parents meet through council or through.
Yes.
And Mr. Jangal is appeared, yes.
My lord, allow us to file a short affidavit, my lord.
No, let's see what is there.
Interim order is in their favor.
This fellow is blessed, whatever his name is. What is this?
Bless is the leading.
Whose signature is this?
Headman Mauling agreement.
The agreement signed between Headman Mauling, my lord, and Bless Padaks. is appointed an agent for collecting electricity bills by that man. Under what authority, my lord?
No, where is written?
It says, well, agreement for connection of electricity and water. The executive committee of Molingna Village Darbar is resolved to permit Srimati Bless so-and-so to collect water from the village water tank and further to obtain electricity connection from the electrical post situated at so-and-so as per the terms and conditions mentioned below.
No, nothing to say appointing as one person. This lady just to draw water from a tank.
Not only tank water, my lord, obtain electricity connection from the electrical post.
No, I mean, she has to go to proper channel. It's not she's going to go and connect herself.
That's not the authority of
That's what the village is allowing him.
No, it's just, see, what happens here is that you want a connection, they have to get some kind of confirmation that you're a resident of the village.
the rates.
I don't think this is anything.
The charges have to be paid to Dushnam.
Kindly see para 2, my lord. You shall pay the charges at such rate prescribed by the EC of Molingna Village Darbar.
For drawing water.
The reserves the right to revise, increase, decrease the rate of registration.
Kalau rai ban ai bat ban cha ye kong bless padak siege ban tan na top jong kasnong baba time light no post light to draw water from the village
village pond
village thing. I don't think there's anything.
In terms of
this village is not a party here.
We'll file our reply. Interim order will continue.
And I kindly say this one also.
Oh, this was okay, yes. Yes, 11.3. Yes, Mr. Nongburi has an appearance in behalf of the impleted respondent number 8.
Number 8, my lord.
Praise about 1 week time to file
your lordships have impleted the chairman by name, my lord, by person. It should be Sanjuk, my lord.
Doesn't matter. We will can correct it later on. Improvise by number 8. I praise for 1 week's time to file affidavit stuff. Next paragraph. Dr. N. Mozika has also submitted that in spite of the orders of this court, the headman, that's one number 7, represented by Mr. H. L. Changre.
My lord, no, number 7, my lord. Number 7 is the Mausanram village.
Yes,
they are the members of the Sanjuk.
Yes.
No, but this is not my village. My relative friend is producing documents bearing a different village, different headman.
Molingna is different.
Who is not a party in the requisition.
The members of same Sanjuk.
No, we will say this is by Wailo area. This one is different.
It's a separate
Wailo
village.
is far from Mosanram.
Separate village.
Falls under Mosanram division.
But Mosanram headman will not be the same person, no?
No.
The headman's name is given, Maulum village.
Now the Wailo headman, so you have to implead him then.
Exactly. If he wants to press.
They are members of the respondent number 8, my lord, all of them. With a Philomus client.
The purpose of Sanjuk is totally different, my lord.
Yeah, Wailo is a member of the Sanjuk.
Yes, my lord, around 300 villages, my lord.
Yes, okay. Ms. Philemon has entered appearance on behalf of the chairman of the Sanjuk weekly as in charge ng Mosanram. He submits that he will be representing the entire Sanjuk. Yes, submission is recorded, sir. Next paragraph, Dr. Muzika has today produced some documents showing a successful letter dated 11/3/2026, which indicates that there is still obstruction of the work by headmen of Wailoi area. Stop. And also, this agreement has no meaning. Also, an agreement, and also letter dated 3/8/2025, issued by the. This is Molong Bana also by Rambashnang Molong Bana. Mr. Philemon Nombri to in his affidavit to address his issues. Yes.
Similar prayer, man. I will be allowed to file a
also for number 7. Please, he is allowed further 1 week's time to file affidavit. This is a call. Where's number 4? Your 4.
Meghalaya Power Distribution Corporation Limited, my lord.
Other respondents, that is number 4, represented by the Advocate General, 5 and 6 by P.S. Nongbri, and who else is there? Yes, we're trying to file required affidavits. It's a huge area of Mosanram.
In fact, under the subdivision, part of Mauklang, entire Mosanram and Ranikor, my lord. That's a subdivision.
But the FEDCO, they have given the NOC, my lord. This new company, they have not given the NOC. But all those, and in other areas also, Kulbari, Nangal, Mansilam, we have the same system, my lord.
Hearing supplementary list 7.
7.
My lord, this is the Nehu regularization matter, my lord. So on the last date, my lord, where we left was those two judgments, my lord, which they were referring by saying that our prayers cannot be considered. That we brought these two judgments, my lord. And these two judgments were passed by this honorable court, my lord. The distinction between these two judgments and ours, my lord. First of all, my lord, the judgment of Tanbor Lapnang, my lord, if my lord will see that judgment, at paragraph 3, my lord, the factual backgrounds where they have given. Paragraph 3, my lord, has got the judgment of WPC 113. So here, my lord, they have given their engagements, my lord, how they were engaged. So these are all temporary engagements, and there's a break, my lord, and that break is also very long, my lord. Number one thing is that is the difference, my lord. In our case, my lord, there is no break. Over a period, we have obtained a status of a long-standing casual workers doing a regular job, my lord. That is one thing. The second thing is, my lord, why these writ petitions were dismissed was because they were asking for a regularization on a post which was not in existence at that relevant point of time. So the court says that you cannot ask for a regularization on a post.
Where does the court say that?
My lord, paragraph 5, my lord. Paragraph 5. Paragraph 5, my lord. Paragraph 5, I'll just say, from the pleaded case of the petitioner in the writ petition, nature of their engagements and the affidavit or file by the respondent, it is clear that the petitioners have been engaged as casual employees on daily wage basis for a certain period without following the procedure prescribed under the constitutional scheme of the public appointment. Over and above, the petitioners were not appointed engaged in a sanctioned post, but they were engaged in daily wage basis without following the required procedure.
You also daily wage?
My lord, there's a break.
Doesn't matter.
They have a break, my lord. We don't have a break, my lord. And now, my lord, I have demonstrated, my lord, then, my lord, paragraph 6, before paragraph 6 from 1, 2, 3, 4, 5, 6, the sixth line, the second line from the following page, my lord. But in the instant case, there are no regular posts or regular vacancies for regular appointment of the petitioner, and therefore there is no question of filling up of regular vacancies or regularizations of the casual services of the petitioner. So, my lord, now I have demonstrated the other day, my lord, even our post, even taking total of the total sanctioned post, regular post, our members occupied post. Yes, yes. In spite of that, my lord, there is an excess, which means that, my lord, there is at that relevant point of time when these people have come, my lord, there was no regular post. So therefore, the court says
that.
This is
There's
where
no question of filling up regular vacancies or
yes, yes.
Not as right. That's why you're asking the same thing. You're asking to be allowed to that your petitions be fill up regular vacancies.
My lord, at this point of time, my lord, there is a vacancies which we are occupying, and those are sanctioned posts. If you see the cadre strength which I've pointed out through my RTI, my lord. So therefore, my lord, those two distinct features, my lord, which differentiates us from the previous petitioners and us, my lord. Now the third very important one is, my lord, all these judgments that has been referred, my lord, is post Jago, my lord. Now the the pre-Jago, my lord. Now the post-Jago has entire changed the service jurisprudence of regularizations, my lord. It doesn't matter, my lord, in which way you have come, because here, my lord, our appointment has never been challenged by the respondents. They are not saying that it's an illegal appointment. They are not saying, my lord. It is an admitted fact. They have admitted that we have been serving for over a decade. Our members are serving for over a decade, my lord. The only objection that they are using now is, my lord, they are saying that no, it's not a sanctioned post. We have demonstrated it is a sanctioned post. on which we have been allowed to work, continue to work, my lord. Jago, that's exactly why Jago has come, my lord, because you cannot exploit the services of, exactly where we are fitting into this Jago's case, my lord. Second part, their objection was these judgments, my lord, referring on these judgments, my lord, ratio decidendi, my lord, they're saying that you cannot come to us, my lord. But this judgment is totally on a different premises. Break is there in those judgments, my lord, in those petitioners, my lord. We don't have a break, my lord. And it's an admitted fact also. Those judgments, my lord, there was no vacant post, no regular post was there at relevant point of time. We have, my lord, we are occupying, my lord. Those judgments, my lord, it came pre-Jago, my lord. Now we are in the post-Jago era, my lord. So, my lord, having all this, and also, my lord, the other case that was followed, my lord, in 458 writ petition also, my lord. On the premises of 113 writ petition, this was also dismissed, my lord. So this also stands on a different footing than ours, my lord. So therefore, my lord, our engagement and our status, my lord, completely can be carved out. Therefore, we are not. That is the reason why I've been saying that these judgments are not in judgment in rem, my lord. These were judgment in personam, my lord. So therefore, this cannot come to the rescue of the Northeastern Head University, my lord. So therefore, my lord, my prayers, my lord, so my lord, on these premises, my lord, I humbly pray, my lord, my prayers for regularizations may be considered, my lord. There may be the directions for consideration of my regularizations, my lord.
Just see Jago. What does it say?
Jago, my lord. Yes. We can go from paragraph 10 onwards, my lord. And because paragraph 8 and paragraph 9, these are the submissions, my lord. I pointed out the other day. Paragraph 8 is the submissions which is supporting us in our case also. Paragraph 9 is the argument of the respondents, my lord, in the same grounds that I've taken, my lord. Now from paragraph 10 onwards, my lord. Having given careful consideration to the submissions advanced and the material on record, we find that the appellant's long and uninterrupted services for periods exceeding well beyond 10 years cannot be brushed aside merely by labeling their initial appointments as part-time or contractual. The essence of their employment must be considered in the light of their sustained contribution, the integral nature of the work, and the fact that no evidence suggests their entry was through any illegal or surreptitious route. The appellants throughout the tenure, this is again, my lord, this is the nature of work, what we have been doing also, my lord, despite, my lord, now, paragraph 12, despite being labeled as part-time workers, the appellants perform this essential task on a daily and continuous basis over extensive periods ranging from over a decade to nearly 2 decades. Their engagement was not sporadic or temporary in nature. Instead, it was recurrent, regular, and akin to the responsibilities typically associated with sanctioned posts. Moreover, the respondents did not engage any other personnel for these tasks during the appellant's tenure, underscoring the indispensable nature of their work. 13, my lord. The claim by the respondents that these were not regular posts lacks merit, as the nature of the work performed by the appellants was perennial and fundamental to the functioning of the offices. The recurring nature of these duties necessitates their classification as regular posts, irrespective of how their initial engagements were labeled. It is also noteworthy that subsequent outsourcing of this same task to private agencies after the appellant's termination demonstrate the inherent need for these services. This act of outsourcing would effectively replace one set of workers with another, further underscores that the work in question was neither temporary nor occasional. Now, my lord, we'll skip that one and paragraph 16, my lord. The appellant's consistent performance over the long tenures further solidifies their claim for regularization. At no point During their engagement, did the respondents raise any issues regarding their competence or performance? On the contrary, the services were extended repeatedly over the years, and their remuneration through minimal was incrementally increased, which was an implicit acknowledgement of their satisfactory performance. The respondents' belated plea of alleged unsatisfactory service appears to be afterthought and lacks credibility. And my lord, this is then paragraph 19, my lord. It is evident from the foregoing that the appellant's roles were not only essential but also indistinguishable from those of regular employees. Their sustained contributions over extended periods, coupled with absence of any adverse remark, warrant equitable treatment and regularization of the service. Denial of this benefit, followed by their arbitrary termination, amounts to manifest injustice and must be rectified. It is well now. Oma Devi, my lord, comes. Oma Devi is. Then, my lord, that's Oma Devi's discussions. Then, my lord, 26, paragraph 26, my lord. What is Oma Devi about, my lord? While the judgment in Oma Devi sought to curtail the practice of backdoor entries and ensure appointments adhere to constitutional principles, it is regrettable that its principles are often misinterpreted and misapplied to deny legitimate claims of long-serving employees. This judgment aimed to distinguish between illegal and irregular appointment. It categorically held that employees in irregular appointments who were engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of the employees, even in cases where the appointments were not illegal but merely lack adherence to procedural formalities. Government departments often cite the judgment in Oma Devi Supra to argue that no vested right to regularization exists for temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. This selective application distorts the judgment's spirit and purpose, effectively weaponizing it against the employees who have rendered indispensable service over decades. My lord, now in light of this, the regularizations was allowed, my lord, in Jago. So therefore, my case also, my lord, squarely covers comes within the coverage of the Jago, my lord.
Yes, Mr. Sen.
May it please your lordships. My lord, as my learned friend has pointed out, my lord, university also relied on the issue decided in writ petition number 113, my lord. What is that? 113 of 2011, your lordships. Now that was decided, my lord, on 16/4/2003. Now, admittedly, my lord, two issues were placed before the bench, my lord. The one is, my lord, the writ petition was filed, my lord, seeking similar relief, my lord, pursuant to what has been provided in para 53 of Uma Devi, regularization. Now, there, my lord, after looking into the records and the submission made by the respective council, the, my lord, learned single judge, my lord, formulated two issues, my lord. Number one, looked into two issues, my lord. Number one, whether the appointments were made against sanction post. Number two, whether the appointments were made pursuant to some kind of recruitment. That's very important, my lord. Some kind of recruitment. And then, my lord, on the basis of the record, my lord, learned single judge has held, there was no selection at all. No selection at all. There is a huge difference between, my lord, illegal and irregular.
Yeah.
Now, thereafter, the learned single judge, my lord, I'll just take my lord, cited those relevant decisions, my lord. Where, my lord, in fact, Uma Devi itself, my lord, in paragraph 15, my lord, what is illegal appointment, irregular has decided. But subsequent judgment, my lord, they have crystallized, my lord, what will be illegal and what is irregular. Now, learned single judge has gone into it, my lord. What is illegal and irregular, my lord, and ultimately came, my lord, relying on those decisions, came to the finding, my lord, that there was no selection. So, my lord, had there been irregular appointment, my lord, that could have been cured, pursuant to, my lord, what has been provided in 53, my lord. Now, my lords, if I can take your lordships, starting from, my lord, paragraph 8. Where is that? Paragraph 8. Para 5, my lord.
Yes.
From the pleaded case of the petitioner, the writ petition, nature of their engagement and affidavit in opposition filed by the respondent, it is clear that the petitioner have been engaged as casual laborers daily wage basis for a certain period without following the procedure prescribed under the constitutional scheme of public employment. Over and above, the petitioner were not appointed against in sanctioned posts, but they were engaged in daily basis without following the required.
Now you're saying that they're same.
They are same, my lord, because Lordship will see that Jaggo has not diluted the ratio laid down by my lord Uma Devi. It cannot be. This Puranchand did the same thing. That Puranchand has diluted. And when Puranchand was placed before a larger bench, my lord, there was a severe reaction, my lord. I have those very severe reaction, my lord. Now, how two judges' bench could have diluted, my lord. But here, my lord, Jaggo, I will not say they have diluted. They have relied on that decision, my lord. Relied on the ratio laid down, and para 26 just now read by my learned friend, again they have reiterated that what is provided in Uma Devi. Uma Devi said illegal and irregular. Irregular can be rectified, but that has been misused by the employers. But here is a case, my lord, admitted cases, my lord, no recruitment at all. No recruitment at all, your lordships.
No, engagement daily wage basis doesn't mean recruitment. It's just
my lord, just. There is no recruitment. Had there been a semblance of recruitment, then of course, my lord.
I've seen Jaggo, there is a semblance of recruitment.
26. My lord, that your lordship, I'll take my lord to that. Now, before that, my lord, if your lordship wants, my lord, what is illegal, irregular? In the same judgment the court has discussed. The court has relied on Supreme Court judgments. My lord, and they my lord, came to a finding, my lord, what is the illegal and what is irregular appointment. Now here, my lord, not even this is not a case of irregular appointment which can be cured.
Yes.
Yes, no. Nine. If I can take my lord to paragraph 9.
Yes.
The public employment as laid down by the Constitution and the law made thereunder, and the Constitution envisages employment by the government and its instrumentally on the basis of the procedure established in that behalf. Any public employment has to be in terms of the constitutional scheme. The court has always kept the legal aspects in mind, and therefore the person who get employed without following a regular procedure or even through backdoor or on daily wage basis, approaching the court, seeking direction to make them permanent, are not welcomed by the court, and their case are not entertained in as much as High Court are not invoking wider jurisdiction under 226 of the Constitution of India to defeat the concept of social justice and equal opportunity for all in the matter of public employment as recognized by our Constitution. The court desist from issuing order preventing regular selection or recruitment at the instance of such person, and from issuing direction for continuance of those who have not secured regular appointment as per procedure established. It is equally well settled that wide power of the High Court under 226 of the Constitution are not intended to be used for the purpose of perpetuating illegalities, irregularities, or improprieties, or such scuttling of whole scheme of the public employment. Regularization cannot be said to be a form of employment, my lord. That is that we can skip. Then your lordship, if I can take my lord to paragraph 16. 16. My 16, 17, 18, my lord. That is very important. The apex court in the state of Karnataka versus G.V. Chandrasekhar reported in such and such had considered para 53 of the judgment of Umadevi and held that regularization is not permissible where initial appointment vis-a-vis is illegal and contrary to the constitutional scheme. Paragraph 26, 27, 29 of the has been reproduced, my lord. So here is also a judgment, my lord, where, my lord, here admittedly a case, my lord, there is no selection, no recruitment at all. Now, if I can take my lord to para 17. The apex court in state of Karnataka versus ML Kesri and other 2010 9 SSC 247 again considered and discussed the contents of para 53 in Umadevi's case and held that appointment of an unqualified person made against the sanction post without following the process of open competition is illegal, or in other words, appointment of qualified person against the sanction post following all the procedures provided under the Constitution in public employment except one of the procedure which does not go to the root of the appointment is irregular appointment, and only an irregular appointments in terms of 53 are to be considered for regularizations. Well, so they have, apex court has defined, my lord, what could be some procedural lapses. There is a selection, there is a public employment, public notice, but there are some procedural lapses that can be corrected, your lordship. And this fact has been acknowledged in Jaggo in para 26. They have again reiterated, my lord, that it is only in the case of, in the case of irregular appointment, my lord, regularization cannot be denied. So, my lord, it is wrong, my lord, that two judges bench has diluted Umadevi. Cannot be, it's a constitutional bench judgment, my lord. And 53 is still holding the field. So, my lord, considering these aspects, my lord, since there is no selection, no recruitment at all, my lord, this case was dismissed. Appeal was preferred, my lord. Appeal was not pursued and withdrawn. Now there was a second round of litigation. Same people they came and filed a, my lord, fresh writ petition in 2019.
Yes, that's here.
No, single bench. Single bench. 2019, my lord. That, my lord, I have given a list.
Yes, we have. That Justice Mittal says.
Yes, this is Mittal. Now, my lord, there in the, my lord, considering that the issue have already been decided, my lord, this has been pointed out that they had approached the court and the issue has been finally decided, my lord. This honorable court dismissed the writ petition with further observation, my lord, at paragraph 4. In view of the above, petitioner precluded from approaching the court again for similar relief which had been declined earlier occasion with the finding against them as noticed above. Accordingly, the prayer made in the writ petition cannot be acceded to. Consequently, the writ petitions are dismissed. Now, my lord, from this again an appeal has been prepared, and that was also not entertained. Finally. So, my humble submission, number one, my lord, Jaggu has not diluted. If your lordship look into paragraph 26 of Jaggu again, my lord, Jaggu. Yeah, I got it. My lord, it is reiterating, it is acknowledging, it has to acknowledge, my lord, it is acknowledging what has been laid down in, my lord, paragraph 53 of the Umadevi's case. There is in para 26, my lord. We can, my lord, the cost of repetition. While the judgment in Umadevi sought to curtail the practice of backdoor entries and ensure appointment adhered to, my lord, will take note, adhere to constitutional principle. It is regrettable that its principles are often misinterpreted and misapplied to deny legitimate claims of long-serving employees. My lord, I'll just pause here for a while. Legitimate claim. What can be a legitimate claim, my lord, in pursuant to Umadevi decision? Those who entered the service, but, my lord, the recruitment process, certain irregularities are there. It's not a case, my lord, where the appointment, my lord, without any recruitment, my lord. That is not the case. These judgments aim to distinguish between illegal and irregular appointments. It categorically held that the employees in irregular appointment who were engaged in daily sanction posts and had served continuously for more than 10 years should be considered for regularization as one-time measure. That is true, my lord. We are not denying. That is what has been laid down clearly, categorically, my lord, by Umadevi. Now, the other aspect also, my lord, will look into it. So far that Jaggu is concerned, my lord, all the appointments were made pre, my lord, Umadevi judgment. Before the Umadevi judgment, appointments were already made. They were inducted at daily wages. And 53, what is the language, my lord? As one-time measure, those who are already in service on the date of judgment. That's what it says. Now, here, if your lordship come into these cases, almost, my lord, 90% cases, my lord, well after the Umadevi judgments, they were inducted. Well after Umadevi judgment. So, my humble submission, my lord, what my learned friend is saying, my lord, that this has been, my lord, this judgment has departed from the ratio. Well, it cannot be and it could not be. Two judges bench cannot do that. It happened only in Puranchand, my lord. Puranchand, it happened, my lord, but if your lordship wants, my lord, that it came up for consideration before that official liquidator.
See?
This is a very severe reaction from the court, my lord. 75 and 76. That is, my lord, the citation is 2008-10 SSC, page 1. (2008) 10 SSC, page 1. Relevant paragraph starts from paragraph 75. It's a long judgment. You can take my lord to paragraph 75.
Yes.
Yes, I just read. By virtue of Article 141 of the Constitution, the judgment of the Constitution Bench of Karnataka versus Umadevi is binding on all courts, including this court, till the same is overruled by a larger bench. The ratio of the Constitutional Bench judgment has been followed by different. The ratio of the judgment has been followed by different two judges benches for declining to entertain claim of regularization of services made by ad hoc, temporary, daily wage, casual employees, for reversing the orders of the High Court granting relief of such employees. India drugs such and such. However, in UP versus Puranchand Pandey, on which reliance has been placed by Sigupta, a two-judge bench has attempted to dilute the constitutional bench judgment by suggesting that the said decision cannot be applied to a case where regularization has been sought in pursuance to Article 14 of the Constitution of the India, and same is in conflict with the judgment of 7-judge benches, Manaka Gandhi versus Union of India. The fact of UP versus Puranchand Pandey, where that the respondents were employed in daily wage basis by the supply, the society has taken over by the Uttar Pradesh Electricity Board in 1977 along with daily wages employees. Earlier to this, the Electricity Board had taken a policy decision on such and such to regularize the services of its employees working on daily wages from 4590 subject to their passing examination. The respondent moved the High Court claiming benefit of the policy decision dated such and such. The learned single judge of the High Court held that once the employee of the society became employee of the Electricity Board, there was no valid ground to discriminate them in the matter of regularization. The division bench approved the order of the single bench. A two-judge bench of this court dismissed the appeal of the Electricity Board. In para 15 of the judgment, the two-judge distinguished the state of Karnataka versus Umadevi by observing that the ratio of that judgment cannot be applied to a case where the regularization has been sought for in pursuance to Article 14 of the Constitution. The two-judge bench then referred to the state of Odisha versus such and such. We are of the constrained to refer the above decision and principles contained therein because we find that often Umadevi case is being applied by courts mechanically as if it were a formula without seeing the facts of a particular case. As observed by this court in such and such, a little difference in facts or even one additional facts may make a lot of difference in procedural value of the decision. Hence, in your opinion, Umadevi case cannot be applied mechanically without such and such. Now, my lord, these we can skip, my lord. That is the observation given in Puranchand. Now, if you come, my lord, 77. We carefully analyze the judgment of the two judges bench in Puranchand and are of the considered view that the above reproduced observation were not called for. The only issue which fell for consideration in the two judge bench was whether the daily wage employee of the society, the establishment of which has taken over by the electricity board along with the employees, were entitled to regularize in terms of the policy decision of the board, and which the High Court committed an error by invoking Article 14 of the Constitution for granting the relief to the writ petitioner. The question whether the electricity board could frame such policy was neither raised nor considered by the High Court, and the High Court simply adverted to the facts of the case and held that once the daily wage employees of the society became employees of the electricity board, they could not be discriminated in the matter of implementation of the policy such as. There has been several instances of different benches of the High Court not following the judgment and orders coordinate and even larger benches. In some cases, High Courts have gone to the extent of ignoring the law laid down by the court without tangible reason. Likewise, there have been instances in which smaller benches of this court have either ignored or bypassed the ratio of the judgment of the larger benches, including the constitutional benches. These cases are illustrative non-adherence to the judicial principle which sine qua non for sustaining the system. Then, my lord, I will take, my lord, to paragraph 92. In the light of what has been stated above, we deem it proper to clarify that comments and observation made by the two judge bench in UP versus Puranchand should be read as an obiter, and the same judicial and same should neither be treated as binding by the High Courts, tribunals, or other judicial, nor should be relied upon on made basis for bypassing the principle laid by the constitutional bench. So, my lord, here, my lord, what I will say, even in Jaggu, my lord, I am not saying there is no deviation, my lord. I don't say any deviation. This has reiterated the principle laid down, my lord. So, for irregular appointment is concerned. Now, my lord, this order has been passed, my lord, specific to a situation in that case. There the court has specific to the situation there, my lord. There, my lord, court has admitted only thing they can cure irregular appointment.
Even Jaggu.
Jaggu. So they have said only thing in irregular appointment, and they have, my lord, it appears they have considered and they have, my lord, though it is not explicitly provided in the judgment, they are satisfied that there are irregular.
Yes. Anyway, yes, continue.
The appointments are irregular. That means there was a selection process, but there are some procedural lapses, and on that ground, my lord, regularized, issued the direction, and there was a termination. That case, there was a termination also, my lord. Termination was satisfied.
How many sanction posts are there? Is that correct? What have they given the petition?
My lord, now your lordship is aware, my lord. I'll just let me explain, my lord. Let me explain. My lord, so far, initially, my lord, when their appointments were made, my lord, as casual, they are not against any sanction post. Now, my lord, so nature of duties, my lord, mostly belong to at that point of time Group D. Now your lordship is dealing with other matters also. After 6th pay commission, my lord, by 2010, Group D posts have been abolished. Now these has been redesignated in Group C, my lord, with higher qualification and even in some cases technical qualification like IIT, diploma and all these things. My lord. That's how come. Now, my lord, the government of India, my lord, have issued a model recruitment rules for that. How the selection committee, advertisement, and that has been, my lord, extended to the university by the UGC, and we have adopted it. So, my lord, any appointment in those posts, my lord, Group C, A, B, C, and all lordship.
Now these posts that are there, as per RTI, will come to Group C now.
These are all, my lord, Group C. He's admitting these are Group C and above.
Group C, you've been all Group C posts.
Group C, my lord. Group C post.
Group C post.
Then no effect.
Yes. So my humble submission, my lord, Jaggu is of no help. Jaggu is of no help. And lastly, I will cite, my lord, once the issue is finally decided, unless it is, my lord, a judgment par incuriam, it cannot be reopened. That's what the Supreme Court has said. 2025 SSC, my lord, online.
I think because we can't generate judgment now, I'm very short of secretary.
No, my lord.
You'll have to just give a written note submissions.
Yes, I can. No problem.
Yes, sir. 2025?
2025 SSC online, SC says.
Examined in the light of the early judgment report and also SC online.
Yes.
Right.
792. Relevant paragraph 22 and 23. You can read, my lord, 22.
Yes.
My lord. Para 22. Though the learned senior counsel for the
And there is no self-assessment report, my lord. So what happens in this scenario, my lord?
Yes. It will become 0 ACR.
It becomes 0 ACR, my lord.
Then?
Now, my lord, so if they go by their submission, my lord, that everything has to be in time, as per the time frame given.
But what are judgments he had placed? There are 2 judgments, I think, of the Delhi High Court on this subject, I think.
That is why I am trying to distinguish, my lord. Because here they are not saying that reporting officers has to be set aside also or expunged. They are sticking, they want the reporting officers assessment, my lord. They want to disown or discard reviewing officer only, my lord. And both are beyond time, my lord. I have shown that. So there can be only one set of argument, my lord. There cannot be pick and choose and double standard for these 2 things, my lord. That's my first line of submission, my lord. Then, my lord, they refer to page 324.
No note attached, secret note.
No note attached. Now, I'll just read para 3, my lord. Para 3 at page 325, my lord. It is further conveyed that the remarks against the integrity columns of APAS and the officers reported upon shall be made by the reporting officer. So this is for the guidance of reporting officer, not for the reviewing officer, my lord. This clause is binding only on, or these are the guidelines only meant for the purpose of reporting officer, not for reviewing officer. Here what they are challenging, my lord? The observations on integrity by the reviewing officer, my lord. So my second submission is, my lord, page 324, 325 will not apply in this case. There is no guidance or no instructions provided how the reviewing officer has to deal with the integrity column, my lord.
Yes.
My third submission is on page 318, my lord.
Three on eight.
They refer to subclause 2, my lord, small Roman 2, a provision may be made in the APAR in the relevant section for remarks by the reviewing officer to indicate specifically the difference, if any, with the assessment made by the reporting officer and the reasons therefore. So this was one of the grounds for challenge, my lord. Now I'll take your lordship to page 62, my lord.
1 second. Saying that he has differed with the reporting officer.
Yes, my lord, and they have given the reason, my lord. Though brief reason, my lord, he says
61.
Yes, 62, my lord.
Yes.
Against serial number 29, my lord, partially agree, over assessed by the IO.
Yes.
And then your lordship will see remarks against column 32, my lord. Yes. The question is, have you improved, reduced the overall assessment made by the IO? If so, give justification. If the overall grading differs by more than 1, the answer is yes. The IO has been liberal in his assessment. So he's given.
So if he does the reason.
He's given the reason, my lord, that he has been over-assessed. He is too liberal in giving the assessment, my lord. Now the question is, my lord, whether this has been complied with or not. Now, in my humble submission, your lordship cannot examine whether this assessment is correct or not, my lord. Whether it has been complied with or not, and I'm just trying to point out that it has been complied with. So there is no infraction of PS 318 as well, my lord.
Yes.
Now, my lord, their case with regard to the next assessment year is that they submitted their self-appraisal on time, my lord. And the reporting officer and the reviewing officer failed to
enter entries.
So the original self-appraisal report submitted by him should be kept in his service record, my lord. So, my lord, the submission that he submitted on time, your lordship has seen, the timeline is 15th April, my lord. And here was a peculiar case, my lord. The officer superior to him was due to retire on 31st January of that year, my lord. So he was required to submit an interim self-assessment, my lord, before he retired, which he failed to do.
Who?
The RETI, my lord.
Okay.
In normal course, if the superior officer is still in service, my lord, the timeline is 15th April.
Now you're saying because he was due to retire 31st January, it was.
He was required to submit an interim report, my lord, till then, which he failed to do. When we asked them,
where does it say? Is it?
I'll point that out, my lord.
Yeah.
The second limb, my lord, that if we ignore this aspect also, my lord, the timeline is 15th of April, my lord. Now, when he submits his self-assessment, my lord, because he says because he submitted self-assessment time, and because there is no action by the reporting and reviewing officer, so his self-appraisal has to be given credence, that has to be accepted, my lord. Now, for that, he has to submit it within time, my lord, because he is so particular about the timeline, my lord. Now, kindly see when he submitted, my lord.
In for 2024.
23-24, my lord. But for this, I'll have to take a lot of affidavit filed as well.
How long will you take?
I'll not take much money. Before lunch break, I think I'll come.
Yes.
Page 182 will indicate, my lord. Para 1. It is submitted apart for the period 1 April 23 to 31st March 24 in respect of Rakesh Chopra was received at this headquarter for initiation of so and so by letter number so and so dated 24th June 20. There is some mistake. Should be 24, my lord. It has to be 2024, my lord. So 23 is mentioned.
Well, where are you from?
But I have no objection. It is 24th June 2024. I have no objection to that.
No, where reading?
Para 1 minute.
Is reported submitted it's 1st June, 1st April 24. No, it's 2024. So
you lost it page 182 minute.
We receive at 24th June 23, right? Yeah.
Is that a typo, Malay? It's 24th June 24. So even he submitted this beyond the timeline, my lord. So the timeline business is all afterthought, my lord.
Yes.
So because because his self-appraisal is submitted beyond time, my lord. Our first case is that he was required to submit by January, my lord. Even we assume that, my lord, even the second timeline of 15th April has not been complied with by him.
Yes.
So the question comes, my lord, reporting officer and reviewing officer were required to adhere to their timelines, my lord.
While he didn't adhere to his.
When he didn't adhere to his own timeline, my lord. Now, what can be the consequences of that, my lord?
Yes.
In my humble submission, the consequence of it cannot be that his belated self-appraisal will have to be accepted. No OM, no rules provide so, my lord.
Yes.
Now, my lord, next they pointed out to page 339, my lord.
Of the repetition.
Of the repetition.
Yes.
In 339, they are referring to clause 9.5, my lord, and subclause 1.
9.5, so yes.
Representations against adverse remarks would be examined by the authority superior to the reviewing officer in consultation. So the stress was that it has not been decided by a superior officer, it has been decided by a subordinate officer. Now, lordship will see page 53, my lord.
Out of the repetition?
Of the repetition.
Yes.
Page 54, my lord. I'll take a lordship the last para. Para 10. And whereas, having considered the representation of the officer, grading by reviewing officer, recommendation of the DGBR, the competent authority has rejected the representation dated so submitted.
So it's just communicated by the.
It's only been communicated by my lord, by the deputy secretary, and this is the normal procedure followed in ministry. That competent authority disposes of the representation in file noting, my lord, and that is communicated through a subordinate officer. So competent authority in this case was defense secretariat.
Yes.
The next reference was made to page 330, my lord. But here their objection was to the environment, something, I'll just point it out. But they are saying, my lord, because the impugned order says that views have been taken from the reporting officer and also from the environment. So their case is that if any views or any input cannot be taken from the environment, and they are, for that they are referring to clause 2 at page 330, my lord. I'll just read once more a few lines of this. As per existing instruction, representation against the remarks or for upgradation of the final grading given in the upper previously known as ACR should be examined by the competent authority in consultation, if necessary, with the reporting and reviewing officer, if any. While considering the representation, the competent authority decides the matter objectively in a quasi-judicial manner on the basis of material placed before it. So our case is, my lord, the competent authority can take into account the material placed before it. And material can be from any source, my lord. can even be from the environment, which are the things of common knowledge, my lord.
Yes.
And my lord, identical provisions are there at page 302 also, my lord. They refer to this also. Clause 4, my lord. Page 302. The competent authority may consider the representative if necessary in consultation with the reporting and or reviewing officer and shall decide the matter objectively based on the material placed before him within a period of 30 days. So there is nothing in the rules, my lord, in the office memorandum that he cannot take any material from any other source apart other than reviewing officer or reporting officer. Now in this case, my lord, what happened? I'll just point out to page 4 of my notes, my lord. In page 4, the third row, my lord. What is your hands?
Yes.
Now their case is that while deciding represent the views of reporting and reviews if still in service to be taken into account. Now here my reporting officer was PK Singh. His comments were received on 23/1/24 and placed on file. Reviewing officer was DG BRO, who is retired by then. His comments were not available. And then we are saying that OM rated decide on the basis of material placed before it. There is no prohibition, my lord, that any other material cannot be taken into account. Now, my lord, the next ground taken by them is that the representation was disposed of over 18.5 months against the timeline of 30 days. Now, my lord, kindly see, if I just refer to my note only. Our first submission is that the timeline again is directory, not mandatory, my lord.
Yes.
And second submission is that, my lord, he came to this honorable court only after rejection of the representation, acquiesced to the delay and challenged the same only after it was negative. He submitted representation on 9/11/23, page 247, and waited till 22/5/2025, and even beyond till 9/10/2025 for filing petition, writ petition, my lord. At this stage, the speaking order cannot be disregarded only for the reason of alleged delay. Even if set aside on the ground of delay, what is the way out? Remanding the matter would cause further delay. Timeline does not say that if representation not disposed of within 30 days and disposed of beyond 30 days, what will be the consequence of that? Whether such order is void, ab initio. And our further cases, my lord, they're referring to the word shall at page 302, my lord. It says, my lord,
authority considers also.
shall decide the matter objectively based on the material placed before him. Our cases, my lord, shall is for the first part of the sentence, my lord, not for
shall place,
my lord. Or even otherwise, this shall has to be read as may, my lord, because these are only directory provisions; they are not mandatory, my lord.
Okay.
My lord, the next submission is with regard to malafides of respondent number 6, my lord. Now it was submitted that the reviewing officer for the first assessment period was Lieutenant General Rajiv Chaudhary, my lord, who was the Director General of Border Roads Organization. And it is also submitted by them, my lord, that he is 4 levels higher than the petitioner, my lord. And it was also a submission made by them that DGBR had no occasion to oversee his work. My lord, If that is so, my lord, what grudge can respondent number 6 have against the petitioner, my lord, when he is 4 level up, he has never observed his work, my lord. And he's a rank of lieutenant general in army, my lord.
Yes.
Now, my lord, the next point will be, is, my lord, that this honorable court in the earlier round of litigation, my lord, quashed the memorandum of charge.
But not the charges.
But not the charges, my lord. It has not wiped out. The allegations are still there, my lord, of belated submission of 3 inquiry reports, my lord, and the department in ACR or in the service record is still entitled to take a view on that, my lord, for non-submission of, for belated submission of the ECS, my lord.
Yeah.
Now, speaking order, my lord, in fact, refers to that, my lord. The impugned speaking order which they are challenging, in fact, refers to that part that at page 54, my lord. Right. So that part has been, that guilt has been taken into account, my lord, the belated submission of the inquiry reports. Failed to complete 3 time-bound departmental inquiries as inquiry officer. So, my lord, to sum up, my lord, the selective rejection and selective desire for one particular appraisal, my lord, by one officer and not by the other officer, when both are
sustainable.
Not sustainable, both are delayed, my lord.
What will be the other way out then? What happens in such cases?
But, my lord, here with the problem, he cannot put for first.
On what basis he becomes for promotion if he's due?
That I'll have to. Because we are proceeding on the basis of existing material, my lord.
Of course, so suppose now whatever.
But the answer for that is in the OM, my lords. The answer for that is in the OM itself.
So in the absence of, where you can't take no qualitative data can be, of APR can be relied upon, what will happen? And if he's in the zone of consideration for promotion, what will be the way out?
I'll have to. If there's, I'm not aware about that part. I didn't have a specific instruction on that. What will be the way out? For first assessment period, my lord. Because there is no self-appraisal.
There's no self-appraisal.
Your lordship set aside a reporting officer as well as a reviewing officer, everything, my lord.
What does APR go?
Then nothing remains, my lord.
Nothing remains, zero.
Yes, my lord.
Then what will record?
Because what we pleaded in the affidavit, my lord, ACR is just one of the aspects.
Exactly. What is the other?
It is not the entire thing, my lord, on the basis of which promotions are given, my lord.
It's not the basis, but it's the most important thing. It's the only one that's supposed to be objective assessment of the officer. Your all other cases, absence of communication for promotion, 3. What is the anyway? Yes, your next point.
So I think these are the points raised by them, my lord, and in fact, I asked my associate to note down all the pages and which pages were referred to in argument, my lord, from YouTube, and try to reply to that point page-wise, my lord. Now I'll just place a few decisions, my lord. One on mandatory and directory, my lord, and the other on territorial justice.
Now, if you can prove directory mandatory, then the whole case goes.
The whole case goes, my lord.
But the thing is that they also are at default in the sense that in submission of appraisal also.
Yes, ma'am. For both the periods.
And how does the
But I prove that is not. But
how does
just see?
Just let him finish. Yes, how?
I'm sorry,
how do you reconcile that if the timeline is to be adhered to, then why send a reminder to him for submission of appraisal That's the thing.
Because that is not our case. That this is, but our case is it is not mandatory. It's directory only. But that's why we issued a reminder to him.
Yes. What is allowed by your guidelines? That's the thing.
Kindly see the reply to that, my lord. If I just place the reply to that one. The reply 176.
One. The evidence that you asked for, it's not copy of me. Oh, we asked for. Okay. Really?
Lordship, kindly have affidavit.
Yes. Have?
Affidavit, page 187.
Okay. Connected. Statement option. Yes. Affidavit.
Page 187. Page 187. 187. But this is not exactly a reply to that notice, my lord, but this is a letter from him, how he tries to justify his non-submission, my lord, in para 3, my lord. Para 2, he says that he was on leave for this period. And then he says, my lord, given my health condition, I was unable to submit my self-appraisal to Mr. Mano Prasad, who retired on 31st January, my lord. However, it is clearly mentioned at para 5.1 of the brochure so-and-so that after expiry of the first week of the schedule, if self-appraisal is not received by that time, the reporting officer should take it upon himself to remind the officer to be reported upon in writing, asking him to submit his self-appraisal. If no self-appraisal is received by the stipulated date, the reporting officer can obtain another blank APAR form and proceed to write the report on the basis of experience of the work and conduct of the officer reported on. This clarifies the reporting officer's responsibility to initiate the APAR process as further detailed in so-and-so, so-and-so, so-and-so. As per para 2.6 of the brochure, where a reporting officer, reviewing officer retires, he may be allowed to give the report on his subordinate officer within 1 month of retirement. It is set procedure that if reviewing officer is retiring in the month of January, he should initiate a review of all the APAR of the subordinates under him before proceeding on retirement or immediately thereafter. It has come to notice that Mr. So-and-so. So he puts every blame on the department, my lord, and disowns every guilt or every default on his part, my lord. As the conduct also, my lord.
Yes. Judgments?
Yes, ma'am. I'll refer to Delhi High Court decision, Vinod Kumar versus Union of India, 2006 SCC online, Delhi.
Swatantra Kumar.
It's a judgment job. Now this judgment is a long judgment, well, it's dealt with all aspects of territorial jurisdiction under 226, my lord, and this has distinguished the territorial jurisdiction under section 20 of CPC, my lord, how it is different from 226, my lord. Whereas lordship seen section 20 CPC says where the defendants reside or where the cause of action. In case of property, where the property is situated, my lord. This in this case, the distinguished, my lord, section 20 CPC will not entirely apply to 220 writ petition, my lord, Because writ petition has to go by the provisions of Article 226 itself. I'll just refer to a few paragraphs, my lord. Para 2. To appropriately discuss the rationale behind the principle of cause of action giving.
Taken a Supreme Court. Does it matter?
I don't think, couldn't find anything. Just check once. The quoted 226, my lord, and then para 3. These provisions clearly exhibit the intent of the framers of the Constitution to grant territorial jurisdiction to the court in whose jurisdiction the entire or part of cause of action has arisen. The purpose of restricting jurisdiction of the court and relating it directly to the cause of action has also nexus to the expeditious disposal of the writ petition. An aggrieved person should approach the court of competent jurisdiction and not file writ petition in the court in whose jurisdiction no cause of action or part thereof has arisen, merely on the ground that the respondents or the petitioners were residents of an area falling under jurisdiction of the court. Article 226(3) of the Constitution, while furthering the cause of expeditious disposal and prevention of unnecessary prolongation of interim orders in the form of injunction or stay, may make it obligatory for the courts to dispose of such application within specified time or within such time as the courts may consider proper reason. Expeditious disposal has relevancy to the administration of justice and therefore is essential to the issue of jurisdiction also. Normally, wherever cause of action or part thereof arises, the authorities would be in power and possession of the relevant documents which can, without any delay, be produced before the court to help expeditious disposal. These are procedural provisions but are mandatory in their form as they alone determine the court of competent jurisdiction. Vesting jurisdiction in court in which any cause of action or part thereof as a reason would amount to defeating the very purpose of the constitutional provisions. In a vast country like ours, the division of jurisdiction would be necessary, which in turn would link itself to the rationale behind these constitutional provisions. My lord, in para 5 they refer to Supreme Court decision Utpal Kumar Basu, my lord. Para 7, my lord, I'll just read few lines. In the light of the above enunciated principles, it is clear that merely because some incidental correspondence was sent to Delhi, which has no material or substantial bearing and integral cause of action in favor of the petitioner, would not vest this court with the territorial jurisdiction to entertain and decide the present petition, as no cause of action, which much less a substantial or integral cause of action, had arisen within the territorial jurisdiction of this court. The parties by consent cannot confer jurisdiction, as otherwise this court has no jurisdiction to entertain and decide the present suit. Now, para 14, there is a reference to Supreme Court decision in Kusum Ingots. They have dealt with that decision also.
Ingots.
So Kusum Ingots.
Where?
Para 14, my lord, I'll just read beyond the dotted lines, my lord. In the case of Kusum Ingots, and so, the Supreme Court clearly rejected the consent that the writ would be maintainable in the court simply because seat of Union of India is in Delhi. The court also held the cause of action would include material and integral facts, and accrual of even a fraction of cause of action within the jurisdiction of the court would provide territorial jurisdiction for entertaining the writ. The court in that case held as under. However, even if a small part of cause of action arises within the territorial jurisdiction of the High Court, the same by itself may not be considered to be a determinative factor compelling the High Court to decide the matter on merit. In appropriate cases, the court may refuse to exercise its discretionary jurisdiction by invoking the doctrine of forum convenience. Now, para 23, Miller. There could be cases where statutory proceedings have been carried out in the jurisdiction of a different court, but the petitioner, by filing a representation before the Chief of Army Staff or a statutory complaint, could bring the case within the jurisdiction of the courts at Delhi. If such a petition was pending and was wrongly decided and the averments and the petition were made against such authority, claiming some relief or direction against that authority. Thus, in the cases of the present kind, it is essential on the rule of statutory interpretation as well as forum convenience seen in light of consistent view of the Supreme Court that the cause of action or any part thereof, even if it is smallest fraction, should have arisen within the jurisdiction of the court concerned. The High Court obviously has the power to issue writ or order to government or any person within its territorial jurisdiction, but the vesting of jurisdiction should be doubted where the authority concerned is neither effectively nor remotely concerned with the process of decision or decision questioned in the writ petition, and no relief is claimed against that party. Location of its office per se, particularly when it is not coupled with any fraction of cause of action, may not be sufficient to clothe the court with jurisdiction to effectively determine the matters in issue. So, my lord, in my humble submission, my lord, only receipt of a representation or disposal of his representation, and even the representation was submitted by him when he was in
Dimapur.
Dimapur, my lord.
Yes.
This is purely a fortuitous circumstance, my lord, because he happened to be posted to Shillong, my lord. It was possible that he was posted to Jammu and Kashmir or Kerala, my lord.
So you see, the only cause of action, the only portion that arose Shillong is the receipt of the
Speaking order, my lord. And something incidental to that, my lord. So it is not an integral part of cause of action, my lord. That is I am trying to stress. This is a 2014 volume 13 SSC. It's not the correct one. Well, para 23 it only says, my lord, this was dealing with Tamil Nadu rules, my lord.
What is the relevance?
Para 23, my lord.
Yes.
Para 23 on the next running page, my lord. This one that is associated.
Mandatory, not directory. You also want to show.
Yes, my lord.
Yes. Yes.
Well, mandatory and directory, I can place one or two more decisions. To sum up, that is our case. There's no infraction of any of
the. What's the decision on mandatory and directory? That is the only guidelines. They're not really.
Yes, well, I'll place by tomorrow. One or two decisions. I'll get the court.
We'll continue tomorrow then.
Well, Maraj, I have just one submission, Maraj. And Maraj, I'll take 10 minutes to respond to the senior advocate, Maraj. So Maraj may not have it tomorrow, Maraj may have it day after tomorrow, Maraj. But tomorrow I am in difficulty, Maraj.
10 minutes, okay, you will take longer then.
It'll take longer. Day after tomorrow then, yeah. But you come out to the authorities.
Yes.
Yes, further.
Can I just show one page as of now?
Yes, no, let them conclude, then we will hear your submission.
Yes. Very well, Manoj. Very well. But Manoj, I can make one request, Manoj. I will be in Shillong, Manoj, physically on 26th. Manoj, keep it on 26th. I'll exchange my judgments with the senior counsel, Manoj, and I can also have a look at the brief notes.
Okay, so we want to close it. No, yes, 26th. Just for the hearing.
26 minutes, we'll close that, my lords. I just need 10 minutes to respond to what has been argued by the respondent.
Mr. Gupta, 26th, I'll have some difficulty. Let's finish out.
That's my habit after tomorrow.
Day after tomorrow. Just for the hearing on what day after tomorrow is?
20th.
20th. Yes.
Obliged, my lords.
Daily list 58.
I think the other hearing matters, Lordship, since we will be taking evidence at 2 o'clock,
Lordship. Then next week, Your Lordship. Or
then we'll post all the hearings after 1 week.
After a week, Lordship, yes.
Yes. One other hearing. List after 1 week. Also.
Next item also, 59 also after a week.
This batch matters, who's appearing? Is it a small matter or how long is it?
My lord, for today, my lord, because on the last occasion when this matter was heard at length, learned double AG had informed this court that they have already adopted the sealed cover process. My lord, if that copy may be given to me, then I'll be able to, my lord.
Okay.
What cover? What order?
Lordship, in fact, I placed that before Your Lordship on the last occasion.
You give copy to him?
Lordship, certainly I'll do that, Your Lordship.
Will it after 1 week?
Yes,
Lordship, yes.
So I'll have to restructure my arguments.
Communication dated is what is it?
26 November.
26 November 25. Lordship.
Communication dated 26
November 25.
11/25. A copy to communication dated 26 11/25 has been handed over to the counsel, the petitioner. It's after 1 week for further hearing.
Highly obliged.
Where's the batch matters?
65, 66, 67.
Now, what's the matter about?
This is about that lump sum compensation on discharge of low medical
Disability?
category. Yes, disability.
You ready with the matter?
Yes, Worship.
Do it today.
It can be done next.
It can't be done, I think, in 10-15 minutes.
Next week sometime.
After 1 week, yes. Any other matter?
59. 59.
Done which matter, 59?
I'm praying for some time, Lordship.
What's it about?
Was regarding the cancellation of the appointment of the petitioner.
He was appointed as a member of the
Rejection, Your
Constable SF10.
Okay,
but
1 week. Yes.
2 weeks, Your Lordship.
Okay, 2 weeks. Yes.
63.
Hello, Blanche.
63.
So they'll have to take it's supposed to take evidence at 63. 63, yes.
Yes, may I please, Your Lordship?
Yes.
Yes, my conducting counsel for today, he is not in position to take this matter.
Who's the connected counsel?
And I should no objection, Your Lordship. Can you please fix after 2 weeks?
2 weeks. Okay, after 2 weeks, yes. 65.
65 is connected. 68.
Urgent.
No, my lord, the issue is very limited, my lord, here, because the main grievance is that an application was not filed, my lord. The grievance is that condemnation,
matter.
yes.
We'll have it after 1 week.
Lordship.
On the pair of parties after 1 week. Then 69.
69.
This is the disciplinary proceedings matters. They have challenged the
Managing the DP, Lordship.